Hey guys, it's Kathy. I hope you're doing well. Wow, we got a stream going at 8:30 p.m. That's crazy. This is a crazy time to start a stream. There's actually people awake right now that might come up. Tina, hi. All right. So, I did tell you it's Kathy with a K. Yep. Hi, Carolyn. Oh my goodness, you're early, Carolyn. We're both early. What are we doing? All right. I did tell you last stream, hi Cheryl, that I stopped the Fleischer clip early because the stream already went on for like 2 hours. Hi, Stink Guy. Hi, Diana. And I do have the rest of that. There's not that much more left, but I'm gonna play that today. I'm not gonna play it first. 5:30. It's still late out there. I'm not gonna play it first to give everybody time to climb into to the live here. So, wow, we're doing a live at 10:30 a.m. tomorrow, Carolyn's time. That's crazy. So the first place we're going is California, and this lady, once the judge starts telling her how she again broke the law, she does this little oh shit dance that I love. It's so cute. Hi, Elizabeth. Let's go. Let's get into California. I love this judge. I just love this judge.
15 Constancio. Okay, that's good.
Claudia Elaine Constancio, is that your true and correct name?
Yes, ma'am.
This is case 23 MI 010347 and case 24 FE 001979, both on for return on a bench warrant for the proceedings, public defenders appointed.
Thank you, Your Honor. Stacy Jackson accepting the appointment. In your honor, for each file.
I just want to tell you about that. While I've been gone, it's okay. While I've been gone, I went to Mexico right after I got out of jail the first time. And I went to rehab in Mexico, and you guys can call and verify. And I've always been.
Constancio, let me explain something to you real quick.
Uh-oh.
I'm just gonna stop you right there. Because you were placed on pretrial condition by the court. Nowhere in there did the court say that you could leave the country to go do rehab.
So I'm
What
telling myself.
the court had also indicated to you that there were requirements that pretrial services needed to know how to get a hold of you.
I know, but I'm homeless, senora, and they jacked me for all my.
I'm just telling you, there were conditions that you were placed on, you violated those conditions, I'm not gonna re-release you.
So do you want to come back next week to try to resolve this case next Thursday? That's 1 week away. Or do you want to write the down?
Wait, what does that mean? I won't be released, senora?
No.
No, I'm not gonna let you out, no.
I'll go to detox.
Miss Constancio, I've already given you that chance, I'm not giving it to you
It
again.
isn't medically necessary, all the times that I have been.
I've made my ruling, Miss Constancio, I'm not gonna change my mind.
Let's come back April 18th, please. 8:30, Department 63, and depending on how the case moves from there.
April 18th, 8:30-63, that'll be the order.
All right, thank you. Returning to page 28, Johnson.
Returning to Jonathan, what's the request?
Your Honor, maybe we return on April.
She absolutely will not change her mind, period. There's nothing you can say to her. She gives you one chance, and she does. She has compassion. She puts people, on OR bonds when it's the first time or whatever. But she's waiting. She's always waiting. If you mess up, that's it. And you can beg and you can plead and you can cry, and they all do. They go in there. Oh yeah, totally screwed, lady. You are screwed, lady. And her lawyer, poor lawyer, was trying to tell her to shut up. She's like, no, it's okay. My favorite part about this judge is when someone starts talking to her, and then she's like, well, hold on a second. Let me look at that. And then she starts digging. And once she starts digging into your file, you are toast. That's it. You are done. The defender always tries to snap her out of it when she starts digging. tries to say, something about the job or the family or the dog or whatever, and it doesn't work. Hi, Colette. Okay, this next one I think is in Jersey. I think it's in New Jersey. And, you know, we just want to let everybody know just how hard it is on the inmates. I mean, it's so hard on them, guys.
Next. Good, anyone not down? So you still need Shannon?
Good afternoon, sir. In 2C11, your name?
David Bevins?
What's the matter, State versus Bavins under W 2024-0001599-0416 and W 2024-000-160-0416. May I have appearances, please?
Assistant Prosecutor Peter Crawford for the state.
Good afternoon, Your Honor. Robert Kale from the Public Defender's Office on behalf of Mr. Bevins.
Sir, did you watch the video advising you of your rights?
Yes, I did.
Okay, be advised the state has filed a motion to detain. You will not be released today. Your next hearing will be your detention hearing on April 16th. That will be the next opportunity for your attorney to argue for your release, okay? Hello, Mr. Bavins, did you hear
Yes,
me?
it just cut out. It cut out.
Okay. The state has filed a motion to detain you. You will
Okay.
not be released today. Your next court date will be your detention hearing on April 16th. That will be the next opportunity for your attorney to argue for your release.
Okay, I just have one question. I have therapy on Friday and Monday. I actually went to the hospital on Saturday, so I tried to, because all this stuff that's going on is really affecting me. And the girl in question has been reaching out to me.
Sir, do me a favor. Sir, do me a favor. Don't discuss anything about the case. We're aware of your mental health situation. Once the prosecutor has filed his motion, there's nothing that we can do. I did talk to your private counsel this morning. He's not representing you on this yet, but we will be getting the police reports on Monday. Of course, if you decide you want to retain Mr. Suffren, that's fine. If not, we'll get the police reports and we'll prepare your case for Tuesday. But I'd prefer if you say nothing more about the case itself.
All right.
All right, thank you, sir. You can step out.
Maybe if he would have asked everybody in jail very nicely if they would be quiet for a second, he might have been able to hear better. But no, he can't stay in jail, Judge. He has therapy. I mean, that's a good one. It's usually something much worse. My dog has diarrhea or something. No, he can't stay in jail because he has a therapy appointment. But he's going to miss it. Okay. We are going to, I think this is Jersey too. I love this judge. His accent gets me every time. And okay, I don't know how many of you have read Harry Potter, but Harry Potter was just not allowed to ask questions at home because Aunt Petunia and Uncle Vernon didn't like questions. No questions. This judge hates questions. You ask a question, he's gonna answer you in a way you don't like. And I love his answers. They are so good.
Yeah, so I knew there was Officer Mattia when I called you the first time. You didn't answer. And I thought I made a mistake. Your name?
Hello?
Tell me your name, please.
Laura Mercado?
The matter of State of New Jersey versus Laura Mercado, W 2024-003-579-0714, Newark Municipal Court Detainer, W 2020-004-85-0714, $7,000 bail. Your Address, please.
1060 Broad Street,
In what city?
Newark,
Zip code?
07102,
Is there an apartment number?
417.
State satisfied with that address?
Oh, I'm gonna get in
No
trouble
objection,
for
Your Honor.
that.
Thank you.
So I will enter not guilty plea for you. Your public safety assessment shows a risk scale for failure to appear of 3 and new criminal activity of 3. Mr. Prosecutor.
Your Honor, thank you. Your Honor, in this matter of domestic violence, specifically aggravated assault together with weapons possession, we have no objection to the recommendation and imposition of level 1 monthly reporting. As noted, while there's no issue regarding the address in this case, we also seek contact with the victim, Anna Delgado. We also seek a weapons preclusion. Thank you, sir.
No objection from the defense as to those conditions of Ms. Mercado's release.
So you will be released, but you must comply with the following. You must appear for all scheduled court proceedings. Immediately notify pretrial services of any change in your contact information. You shall not commit any offense during the period of your release. You must refrain from any contact with the alleged victim, Ana Delgado, and their residence, and also their place of work. And you cannot have any type of electronic communication with them for any reason whatsoever. And if you violate these no contact conditions, you will face more serious consequences. You must also refrain from possessing a firearm, destructive device, or other dangerous weapon. You must report to pretrial services telephonically once per month. Your next court date is July 22nd, 2024, 9 a.m. before Judge Batista. Public Defender Donnell has been assigned to represent you and will speak with you before your court date to prepare your defense. Do you understand?
Yes, Your Honor. I also have a question, Your Honor.
Don't do it. Don't do it.
What's your question?
My question is, I have a voluntary complete drop statement from the detective and also the victim, which I have
No.
here.
It's not for today. You have to discuss that. You have to discuss that with your lawyers.
Okay.
It's not for these proceedings. And
Okay,
then now you have a bench warrant. So I will give you a second opportunity because you failed to go to court. I will believe that you have learned the importance of going to court by spending at least one night in jail. So I will vacate the bench warrant. The next court date on that matter will be on May 9th, 2024 at 9 a.m. at the Newark Municipal Court. I will waive the bail of $7,000. Now, if you get another bench warrant, if you don't go to court and you get another bench warrant, don't expect that it will be easily resolved the way I have resolved this one. Do you understand?
Yes, sir.
All right, you can now leave the booth.
Thank you so much.
You're welcome. Your name?
Yes, good afternoon. My name is Rasul Burke.
All right, let me address this matter first. Just give me 1 second. The matter of State of New Jersey versus Damien Rivers Mallard, W 2024-005-338-0714 is a case where a screening appears to be needed. That's number 19. And it appears that the screening request is from the jail itself, the officer's observation. It was not ordered by a judge. So that matter is adjourned for recall for tomorrow's court session being April 12th, 2024. Now the matter of State of New Jersey versus Rasul Burt, W 2024-005-362 and 363, both out of 0714. Mr. Prosecutor.
Judge, thank you. Your Honor, with respect to both complaints set forth by the court, we have moved for non-DB detention.
So you will be detained until April 16th, 2024. You will appear for detention hearing before Judge Critchley. Thereafter, your case or both cases will go before Judge Romanation on July 22nd, 2024 at 9 a.m. And Public Defender Burns has been assigned to represent you and will speak with you before your court date to prepare your defense. Do you understand?
Now, I'm saying I've been a resident of New Jersey all my life. I'm not a flight risk, so I don't understand why I'm not being released.
Because you're not. Because the prosecutor filed a motion for your detention. That's how the law works in New Jersey. When the prosecutor files a motion for your detention, then you cannot be released until you go to a detention hearing. You understand?
Yes. All right, thank you.
You're welcome.
Because you're not. That's why.
No.
So, yes, I left the address in that because I grabbed the wrong clip. I had a clip of a girl who was so worried about her stuff, and he's trying to tell her about her stuff, and he's really funny about it. But everybody's addresses are public knowledge. It's right online. They caught a criminal case, so everything is public. But and why do we have their addresses? Because we do. We just do. It's right online. All right, now we're gonna go to a talker. Just can't stop talking. Here it is. Yeah, yeah. Nope, don't do that. Here we go.
To proceed. Next.
This is also Jersey.
Judge, if I may bring a few things to your attention. I'm sorry, it's loud. I didn't hear it.
Yes, you may.
Thank you, ma'am. So I was confirmed with obviously all my clients while I was in the breakout room. Mr. Johnson, we're still waiting on a verifiable address from him. If so, I appreciate your Honor's patience with that. Hopefully it doesn't go past in the afternoon, but I'll keep you updated. And then specifically with Mr. Shepard, he asked that I make a request to the court that we be heard very briefly on the adjournment request made by the state, if the state would be able to reconsider, and we provide some insight as to why we'd be making that request.
You can certainly place any arguments on the record, but the court does note that is a statutory entitlement to the state, and this is their request for an adjournment in that matter. So the court will address the matter of State versus Ronald Shepard under complaint warrant 2024-67-1533. If I may have the appearance of counsel, please, beginning with the state.
Thank you, Your Honor. Lenny DeBessas, Assistant Prosecutor on behalf of the state.
Judge Portia Bethea with the Office of the Public Defender here on behalf of Mr. Ronald Shepard, who is still virtually appearing from Ocean County Detention Center.
Thank you. Mr. Shepard, please state your full name and spell your last name for the record.
Ronald Joseph Shepard Jr., SHEPPARD.
Thank you. I will hear from defense counsel.
Thank you, Judge. I appreciate the opportunity. Understandably, we know that the state has its entitlement to a statutory adjournment in this matter, and this is the first time they're asking for their 3-day adjournment. After conferring with my client, he and I have spoken in depth about the need and desire for him to be released, and obviously he'd ask that the state reconsider their adjournment today so that his argument can be heard in front of Your Honor so that he can be argued to get released today. As stated, we understand that the state has its entitlement for its adjournment, and therefore it's out of the judge's hands as far as objecting to that request and even hearing our objection. So we do appreciate the opportunity for reasons that we can place in front of you, specifically playing to AP Domestic Haas for reasons to reconsider the adjournment she made earlier. My client understandably knows the positions he's in. He wants to be released. He wants to reunite with his children, specifically the 8-year-old daughter he has, whose birthday is this upcoming Sunday, the 14th. As just by his presence in the Ocean County Detention Center, he's very, heartbroken that he's not reunited with his children, and more specifically for his daughter. He's been a father since 15 years old himself. He knows the importance of having a father in his life. He wants to be there for his daughter. He's never missed a birthday. And in this instance, it's breaking his heart that he unfortunately was prepared today to have his argument heard for release so he could be present in his daughter's life for her birthday this Sunday. So honestly, we are, at the mercy of the state in regard to our argument that you do please consider your adjournment request for Mr. Shepherd. Thank you.
All right. Any response by the state?
Your Honor, I appreciate defense counsel's argument at this time. The state is awaiting additional reports. We are seeking those reports in order to be adequately prepared in order to proceed with the argument. This defendant does also have multiple motions to revoke pending at this time as well. If I am in receipt of reports earlier, I have no problem asking that the matter be moved up, but at this time, the state is not in receipt of those reports, is awaiting them. So we are still seeking the adjournment.
All right. So the court certainly heard and appreciates defense counsel's argument, but the state is entitled by statute and court rule to an adjournment of up to 3 days. As indicated, this is the state's first adjournment request. Even if it were not, the state has indicated that they are awaiting reports, so the court could also grant an adjournment based upon good cause for those reasons. So therefore, this matter remains relisted for Wednesday, April 17th, 2024. The state has indicated that if they are in receipt of the reports and information sooner, that they will reach out to the court to see about getting the hearing moved up, and at which point the court would certainly attempt to accommodate that request. That will conclude the matter of State versus Ronald Shepherd. Mr. Shepherd, you're free to leave the room.
Nope, that won't conclude it.
Which reports are you waiting on still?
Okay, so the state does not have to answer that question. Your matter is adjourned, Mr. Shepherd.
Not
Okay,
yet.
I'm just asking for. I'm just asking for just for one reason.
Now, Mr. Shepherd, the state has indicated that they are requesting their adjournment. They're entitled to the adjournment by statute and court rule.
I understand that and I respect that. I understand.
So it is granted. That will conclude that.
You said if they were to get a report sooner, then you might hear me sooner. I'm just asking what report are they waiting on?
Okay, the state does not have to answer that question.
Would the state be so kind to answer my question? Mr. Demesta, I'm not.
The matter is concluded for today.
Okay, I'm not trying to be disrespectful. I'm just trying to see what report you're waiting on.
I am not requiring the state to answer that question at this time. Even if they were not waiting on it, they would be able to take the 3-day adjournment by statute and court rule. All right.
Okay, could I speak with my attorney, please?
Mr. Shepherd, somebody from our office, whether it's me or my colleague, will come to the jail to see you. We can't keep pushing the judge as far as I know what the fight.
Yes, again, I'm not trying to be disrespectful. I do appreciate you asking, and AP, I appreciate you telling me why. I just don't know what other report that you're waiting for. That's the only question that I'm asking. That is it.
They don't have that information for us either, but they have to provide it as soon as they get it. So I don't even have an answer for you, even if we went out into the breakout room. But we will definitely be in touch with you well before the next court date and be ready and prepared to get you out of the state.
Can you come and see me today? Because I didn't even see you before court. I thought that I was supposed to see you before court. And
You did see me before court. I came to see you yesterday to prepare for today.
Yeah, I thought I was supposed to see you before court today too, though. That's what I was saying.
No, I apologize if there was that misunderstanding, but we'll coordinate to come see you, whether it be today, before the weekend, or obviously in the start of next week.
Can you please come today?
If time allots, I will definitely try to make my strongest effort, but I do have other cases, so I just. want you to be aware of that.
Is there
Okay, so if there's any conversations, if that can be done between defendant and counsel after these proceedings.
That's what I was about to ask. Can I have your phone number or a number I can get in touch with you with?
But at this juncture, the court does need to continue with its calendar. So I understand we're still waiting on an address in the matter of Michael Johnson. So what I would ask is that the jail remove all of the defendants except John Zach, and the court will address the state versus John Zach.
Okay, Ms. Portia, can I have your phone number so I can get in touch with you, please?
You have something to write with?
You can just say it, I'll go write it down.
Portia, no. So I had to cut it off there because it was all about phone numbers and things like that. But he kept going on and on. He should have got contempt of court, and that lawyer should have gotten in trouble too, because that judge kept telling them to knock it off, and he kept talking, and he kept talking, and he kept talking. But that's Jersey. That's Jersey. I love Jersey. Yeah, and her phone number is also public. It just is. It's her office number. But I didn't put it in here. Okay. Now we're going to go to the last part of the Fleischer of Friday, of his Friday docket that I wasn't able to play the whole docket on Friday. So there's just a few minutes left, like 30. Here we go. Here's Fleischer.
Hi, Ricardo. You got a minute, Judge? Just a breath of fresh air, finally. Come on.
Yeah, page 30.
What do you mean, not yet? Oh, yeah. Not yet. Regardless of it. All right. You said 30?
Yes.
Those days, Judge. I don't think we've ever put as many people in jail as we have today.
Oh, yeah.
What do you want?
Judge, I was just trying to get a reset. I was told to approach because he picked up a new case. And so I'll let the state.
Yeah, I mean, he's looking at a $20,000 bond upstairs. I'll just leave it as is.
As is? Okay,
Yeah,
perfect.
I mean, and then, God, it's so far away.
Yeah, what was it, 6/11? I did just get a
I
point.
don't like to set people so far out. Let's set it out 30 days, come back, and then see if something changes. And then we'll just give you more time after that,
If something changes.
Yeah, because sometimes they, we'll move it up for one reason or the other, and we just never get wind, and people just get stuck,
Okay, so we're gonna keep the bond the same.
Kelly Benavides is representing him upstairs. So, yeah, I'd say, hey, Victoria, 30 days. Yeah. I know, he didn't make the bond on that. Or on ours either. They didn't give him a PR bond. I don't.
Well, Judge, he was discharged. So on the new case, it was two new cases, the theft and the PCS. They were together on 410. They dismissed the theft, but he still has the PCS pending up there.
Happened.
For the theft?
Yeah. They really found no PC on it? They really found no PC
Yeah,
on
they
it?
really found no PC, Judge.
What happened?
I don't know. I can't tell you what.
You think there was PC?
I do think there was PC because the defendant admitted it, but maybe there's a question.
Yeah.
I think there's a question as to if he passed all points of sale. I think that was the ultimate issue in the theft.
Okay.
Because, yeah, the witnesses stopped the defendant at the door. So maybe that has something to do with it.
That's passing all points of sale, is it not?
I would make the argument, yes, sir.
I mean, anytime you pass a cash register, you pass the
Pass all
point
points of
of sale.
I didn't bring up that argument, Judge. I was taking the dismissal.
Yeah, we're not gonna do anything. I'm not doing anything. So yeah, we'll just set it 30 days and then
Sounds good.
have at it.
And we'll keep his original bond the same as it was. Okay.
Sure.
He's got PCSs, so I told him that they work it out. I'm fine.
Okay.
Got it.
All right, thank you, guys. Thank you, Judge.
I want you to get ready on Andrade because I am now going to have a contempt hearing on him.
Oh,
So get ready.
do we have defense on it yet?
Yes, James Sims.
Okay.
I have now set his bond at 20,009 on both cases.
On the date. 'cause I don't
Yes.
have the date yet.
Correct. Yes. Okay,
Three more to go.
who?
And I had also reminded you.
Flores.
Peña,
Okay, hold on.
did you do the bell for Peña?
Okay, I'll do Flores now. Yeah. I think I did Pena already. I'm doing bail orders on Flores now.
Yeah.
Deputy Simpson, did you try to talk to Flores again by chance? Is he better? Oh, he didn't give it to you? He's not better than. I don't know.
So I printed out the copy.
Can we, I'm gonna order it, but I'm gonna order it regardless. I wanna do it. I mean, I most certainly think he needs it.
Oh, but.
Morning, Judge. How are you?
Okay, yeah.
So I'm approaching on an off-docket matter, Your Honor.
Bear with me a second. Let me just sign this real quick. And then. Okay, what is it?
So it's 250-3682, Your Honor.
Rico Romero?
Yes, Your Honor.
Okay.
The reason I'm approaching is he was given a PR bond, then taken to ICE. And so that's the reason for his failure to appear so far. I was able to get him a bond today with ICE.
Oh, wonderful.
So he should be getting released either this afternoon.
What did they set it at?
8,000. And she actually put some conditions on there, which I've never seen from an immigration judge. He has to take Alcoholics Anonymous when he's released, within 30 days. And
You're lucky to get him on though, right?
with this one, yes, Your Honor. I thought the judge was very forgiving.
Nice.
Yes. So the reason I'm approaching is I wanted to see if you would allow this case to just be reset to maybe next Wednesday, or
It's in warrant status. I can't reset it.
can we, would you consider reinstating the bond?
I will.
Okay, thank you, Your Honor. And I will have him appear the day that he's released.
He needs to, right, that's your thing though. He needs to appear. You need to give us a date. And then we expect him, and all we want to do is no drugs, no alcohol, no driving because he doesn't have a license.
Yes, Your Honor.
And then we'll just give you as much time as you need.
Thank you so much, Your Honor.
So we need a date from you now though. Yeah,
Thank you. Maybe excuse Your Honor.
of course. Hey,
Question. I have Mr. Faradman, the guy that doesn't speak English, that speaks Farsi. Only thing that I wanted to approach on is, I saw in the bond conditions that it said no contact with the complainant, which is totally fine, but also no contact with anyone in the household, including.
no, it's not right. That's all we want to do is no contact with the complaining witness. So if they put it on the MOAB, I'll take
I
it out.
disagree
And
with that.
I don't know if I saw it in the MOAB, I'll look at that, but I definitely saw it in the bond conditions.
I'll take it
Because it was
off.
anyone in the household.
Because
Okay.
he wants to have contact with his kids.
Well, and they're grown, they're like 18 and 22, so it's not like, they can have
Great.
independent.
No, they're adults.
Just get it to me, I'll take it off.
Thanks.
And he's approaching on Andrade.
In both, right? in the-
James, hey bud,
I got appointed on it.
wonderful.
Apparently he's got a lot of problems.
So case is 2,400 days old. He's
He has a hired attorney on that one.
not anymore.
Okay, I guess after 5 years.
Ralph was not hired, or was he?
Yes, he was hired. I emailed him asking if he was staying on and I never got a job.
Just, we'll take him off.
Okay, so I'll get attached to that one.
Yeah. So basically what happened was just 9 times MIA. We ended up, he comes back after a bunch of FTAs, we set the case for trial and then begs and pleads to get in the divert program, gets into the divert program, and then has violations and then goes to us for 3 years. He's now back with the new DWI. He had signed a no driving affidavit, obviously. That's why we're also doing this as well. So I set his bonds high.
Okay.
I set his bonds at 20,009 each.
Oh, wow, okay.
Please let him know, because I want him to know how high they are, and also let him know that we're going to have a contempt hearing on him as well. I let him know already.
Would you be
but-
opposed to me trying to work it out before that contempt hearing, or
No,
you're not opposed to it? or-
No.
Oh, okay, okay.
I mean, if you want to work it out, I'm happy to do it.
When you were you planning to have the contempt hearing?
I don't know, we need to work that out.
Okay.
If you want to work out the cases today, I'm happy to do it.
I probably just want a little time to look over the videos.
For sure. Yeah, yeah,
Short
whatever
reset.
you want. Yeah, yeah, absolutely. What? Yeah, hey, James, I'm still doing the show cause. So, I mean, I'm gonna set a show cause hearing, I'm gonna do it. So if you're gonna work it out, I'll probably do it,
Before the show cause day.
but I'm gonna set it for, I don't know, sometime next week.
Okay.
Or I guess depending on, why don't we do this? Let's regroup Monday. Will you reach out to your officers to see what's a good time for them? And then on Monday, I'll set it.
Okay, so roll it to Monday, Judge.
Well, he's gonna pop on Monday's docket anyways, right? So,
Not yet.
can you file it and not put a date, or do you? Okay, so we'll file it on Monday. Yeah. Damn it. Can you print out this page again? Just this one.
Yeah.
No, the second one, the order on state's motion. I think, yeah, it's the third page.
It's the worst.
Okay, that's it. Yes, thanks. Okay. Okay, so Paria, so that's the order, and I just crossed out anyone in the complainant's household, including sibling or parents, and then we'll just do the same thing.
For the Moab.
Yeah.
Cool, thanks, appreciate it. Yeah.
Don't worry, some people will come up soon.
Hi, Hugh.
Hey, good morning, Judge.
Good morning.
I was just appointed to Michael Banks and he's in custody.
Thanks.
Page 20.
Okay.
And Judge, I'd like to see if we can get a PR bond on this. He has no other open cases, at least in Harris County, that I can see.
Stephen, or Simpson, do you mind bringing up Michael Banks, please? Give me I'm bringing him out to you.
Okay, thank you.
Do we know if the lawyer's coming? Yeah, I guess let's try. And if you are unsuccessful, then I'll try. Mr. Banks, how's jail?
Not a place I want to exist in.
Why don't you show up to us?
Huh?
You don't show up to us. We had to revoke your bond because you went AWOL.
I didn't know nothing about provoking anything, sir. When I got released, I didn't even know nothing of a date.
They give you a piece of paper that you signed, Mr. Banks.
Yes, sir.
How you gonna try to play that?
I'm telling you the truth. I did not know nothing. I didn't know nothing.
Is discovery complete in Mr. Banks's case?
Yes, Your Honor.
If you put an offer on the case? Okay. Mr. Banks, your lawyer has asked me to give you a PR bond. I will give you one final chance. If you ever take off again, I'm going to make your bond high. As you now know, no one is willing to bond you out because that's why you're stuck here.
Ouch.
If you ghost us again, I'm going to make your bond even higher, and then you're going to be stuck like Chuck for an even longer time because I will never give you another one. You understand? It is your responsibility to stay in touch with Mr. Brasher, your lawyer. If he tells me again that he can't get a hold of you, I will never do this again. It's now time to decide what to do with your case. Discovery is complete. It's time for you to meet with your lawyer. They're going to put an offer on your case, and by the next time we come back, we need to see what's going to happen. You understand? All right. Do you have a good way to get a hold of him, Mr. Brasher?
No, I do not. I was going to see, Mr. Banks, do you have a cell phone number?
Yes, sir, I do.
On the reset we're going to give you today,
See,
it will
I'm a
have his
professional.
phone number as well. So there is no excuse for you to say that you can't get a hold of him. I'm going to, in fact, circle it for you as well. Do you understand? This is your last PR bond. Okay, thanks. Thanks, you.
And should I just email Victoria about the new date?
Yeah.
Okay.
How's June 25th through the 27th? Ish.
Yes, the 27th will work.
No, gotta be here. Okay, Hugh. Thanks, man.
All right. Thank you. Have a good
Gotcha.
weekend, Judge.
Have fun, you too.
All righty. Bye.
Can I just reinstate it and let him out? Banks? Hey, Jeremiah, I might be able to just reinstate it. That way it'll be easier on you. Hold on a second. Kicking the ding ding. Hey, man, let the guy go make money.
Okay, but I still work here. Okay, so the bond reinstated.
Yeah.
All right. Come on, step over this way. She's gonna have you sign for your recess.
Do you mind circling the lawyer's phone number, please? And then the other one that's open is at no bond, which is that way. Okay. Mr. DeGeiger, good morning.
Good morning, Your Honor.
How are you?
I'm hanging in there. How are you, Your Honor?
I've got Mr. Green back. Come up, Mr. Green.
Yes, Your Honor.
It's the name. That's all. What time is that on? Yes, 10,002.
Where do we go from here, guys? Tell me, Mr. Guida, where are we going from here?
I have got executed subpoena for the various the files associated with the various police reports for this case. This is the one where he is the defendant here, and then the complaining witness for the complaining. The complaining witness here is a defendant upstairs. This is the one where I had the bullet removed from the vehicle, and the state is we're proceeding. We're
Okay, yeah, don't worry about it. So, Mr. Green, if you ever
I just gotta say, some of you might not get this, but some of you definitely will. Guys, imagine this lawyer and Miss Butler in front of Fleischer.
how many people did I put in jail today? Right. If I ever have to do that to you again because you violate conditions, or at worst, pick up a new case, I'm going to make your bond so high, you're going to flip. The other gentleman in there, I made his bond $40,000. So if that's what we have to do to get you to stop picking up criminal cases, that's what we're going to do. I'm ordering you as a condition of your bond to put a GPS monitor on your ankle. I'm giving you a curfew of 9 p.m. to 6 a.m. And I'm also ordering you not to be in possession of weapons. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. Do you understand? If you violate these conditions, I'm going to keep you with me. I'm done playing games. Any more drama, I'm just going to set your case for trial as well. It is your responsibility to stay in touch with Mr. DeGuider. He'll tell you if and when you have to come back to court. I'm going to have you go to Victoria, sign a reset. After that, you'll get what you might be your bond conditions. Behave yourself. Mr. DeGuider, we need a new date from you. I'll do 30 days, whatever you want. I'm happy to do.
I'm supposed to be held.
Mike and Colin, welcome. You guys brought all your peeps over. This is awesome. This is really good. Chat is going crazy, guys. Don't worry, I have chat replay on because I'm a professional. I'm a professional.
Mr. Wasserstein with a trial starting May 13th. So if we could do it the week after the 13th.
Okay. Yeah. May 13th.
The week after that.
21st to the 23rd. You pick a day.
Whatever is easier for the court.
22nd.
All right, 22nd it is, okay?
Thank you, Your Honor.
All right, my friend. Take care of yourself, and we'll see you soon, okay?
Yes, sir. You have a good afternoon. May I be excused?
You got it. Have a good weekend. Any luck?
No, he's still adamant he's not gonna sign any papers.
It's okay.
So
Roll it to Monday. Hopefully the weekend will change things. I'm going to order him evaluated.
Yes, Judge, I'll go ahead and fill out the paperwork as well. That way, hopefully he comes back on medication and he's ready.
It's a 30-day reset, unfortunately. But I'll see what we can do to try to expedite it. Can we expedite that or no?
I think you can always request them to try to do it faster.
I don't even know how to.
It's might have to talk to the lawyer.
Because if you don't, I mean, who's going to give him any kind of medicine in there now?
Well, we're gonna put on our paperwork that he needs to see, is being delusional and all that, so that way he has to see a fight. We wouldn't put that part.
Great. Maybe he'll be medicated by Monday.
We'll get him to see that part. on that part, that might get them to start seeing minutes on there. But it usually takes about 1 to 3 days to sometimes get it started on medicine. So
Let's set it to Monday and we'll go from there.
Yes, Judge.
Yeah.
I was hoping, Marcos and I were talking about Harris County Jail is a dangerous place for him, especially when he's not understanding he's either gonna catch a new charge or.
But he'll be in the medical wing, right? So he's not gonna.
He'll end up, first he'll start there, but if he has no major medical conditions.
But with his mental state and the way he is, won't they determine he's
It depends on how far off he is when he gets to the site. If the site feels that he needs to be isolated a little bit further, they will put him in the site.
What do you suggest?
But they can't guarantee that.
The problem is he's not signing any
I'm
conditions.
not letting him out because he's not gonna sign it. I know that he's just not gonna, he's gonna do whatever the hell he wants to do. He's not gonna follow conditions.
And he's getting volatile, so I don't want to leave it with mom who says he's not gonna take medications either. So let's reapproach Monday. I won't be here Monday, Marcos will be,
Yeah,
but
that's,
he's aware of what's going on. So hopefully he pleads Monday, if not, then I guess we proceed with competency.
yeah.
Thank you, Judge.
You know, what we can do is like what he said, that we'll get in the medical. Hopefully they'll have the wherewithal to give him something and then we'll set it maybe every other day so that he doesn't have to get up so early. And then once that kicks in and he's lucid, then we can,
Yes, Judge.
yeah.
Thank you.
Okay.
Because if he responds to the site like he was responding here, more than likely they will go and give him some kind of medication.
But they can't force it though, right?
So they can't force it to him. He does then, they give a night. Put your arms down, man.
He's digging. This isn't good. He's digging.
I don't understand what this says. This says defendant status deferred adjudication of guilt.
That must have been a typo.
It's gotta be a mistake, right?
Yeah, gotta be a mistake, because we swear it on the first.
All right. Ma'am, you were charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, ma'am.
On January 13, 2024, officers were dispatched to an apartment complex in Harris County, Texas. Officers met with the complaining witness who stated the defendant arrived at his apartment and attempted to fight the complaining witness's girlfriend. Defendant then threw a piece of concrete at the balcony, damaging the balcony sliding door. Complaining witness stated the damage caused by defendant would cost approximately $500 to repair and replace. Complaining witness called the defendant and placed her on speaker. The complaining witness told the defendant she damaged the window and the defendant replied, quote, "I don't give a fuck. I don't give a fuck, don't play with me," end quote. Complaining witness identified the defendant by name and the defendant's Facebook to provide date of birth.
Ms. Ward, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand? If you violate these conditions, I will put you in jail. You will not get any more PR bonds. We are going to reset your case to give you time to hire lawyers. So first, I'm going to have you go to Victoria, sign a reset. After that, you'll take a seat in the jury box. I'll get your bond conditions. We'll have you sign it, and then you'll be on your way. From now on, court starts at 8:30, not 11, 11:02. Do you understand, ma'am? Please. Yeah.
Here we go.
All right. Guys, that's a wrap.
Guys, that's a wrap. No, it's not a wrap. I have a better trial coming on, but that's a wrap. Hi, all first timers. Welcome. Welcome to the professional stream where I do everything wrong, but that's okay. Hey, J Fire's here. Hi, J Fire. All right, so now we're going to go to, I believe, Colorado. I don't know. I keep getting all my states mixed up because I go everywhere. And this judge, 2 minutes in, should have done what the inmate did at the very end. The judge just should have done it 2 minutes in. I have no idea why the judge fought so hard, but she lost. Judge loses, guys. I'm just telling you. Here we go.
Is a mistake. I think it would have been helpful to her not only with sentencing from a more cynical standpoint, but I think in a larger scheme of things, I think it might have exposed her some skills or some awareness to how her drinking has affected her. I know she's aware how it's affected her because she wakes up in the jail every day, but it would have been nice to have her have some additional skills, especially since she's a young mother. And but I pride myself on my powers of persuasion, but I'm not always batting a thousand. Sometimes folks exercise their free agency as she has in this situation.
Ms. Carrillo Vasquez, I guess you're the only one who knows what you want to do. The last report I have from the court states that you did not accept inpatient treatment. You were fine to stay in jail, was the direct quote. Stated you don't have a problem. You're not an alcoholic. And then it also states that you didn't complete treatment. You only went to one level 2 education class. You were on your cell phone the whole time. You left the group and you were asked to stay seated. You were so disruptive that you were asked to leave.
No sé qué decir, la verdad.
Honestly, I don't know what to say.
I need you to tell me what you want.
Caramel Frappuccino.
I think what the judge is looking for is, are you wanting to do something to address your drinking with some classes or some sort of therapy? Are you just wanting her to give you jail and close out the case? It's helpful sometimes to know what your attitude is about this and your feelings about it when she's making these sort of decisions.
Mm-hmm. It would be a waste of everyone's time to resentence you to probation today, only for you to go to group and do the same thing you did last time and just not really. If you don't want the help and you don't think you're an alcoholic, then I'm not sure you're going to get a lot out of the classes.
Pues yo con la persona que hablé, exactamente, yo no le di a entender que no tenía un problema, fue lo que le dije, nomás que no quería ir al problema, pues al programa ese, pero que sí estaba dispuesta a hacer las clases o ir pues a algún otro tratamiento que tengan, pero que no sea de estar ahí.
So, with the person that I talked, I don't think that I conveyed that I just didn't have a problem per se. You know, I told that person that I just didn't want to go to that program, that I was willing to go to the classes and to go to a different type of treatment if they had another one, something that doesn't require me to be in there.
Mm-hmm. But you would rather be in jail than go to an inpatient treatment facility?
Pues la verdad me da igual, pero yo pienso que pues estando aquí o allá, pues es lo mismo.
Well, to me, it's kind of like the same. I think that if I stay here or go there, it's basically the same thing.
And that sounds like someone who doesn't want treatment. So the other thing I wanted to ask, and I don't know if this was done in the Garfield County case, but, and it looks like we have Ms. Steinman on. Was there ever a screen for recovery court for Ms. Carol Vasquez?
I think there was, Your Honor. There was an issue with Fleischer. Sure.
Mr. Maureen, do you have an answer on that? Okay. Or maybe Ms. Steinman knows as well. Ms. Steinman.
Thank you. Sorry. I did speak with Matt Mooring about this. She was going to be, or she was screened for recovery court. He can correct me if I'm wrong, but I think the issue was where she lived and she wouldn't be accepted into the Pickens County recovery court program. Can you confirm that, Matt?
Yes, it was. There would be some language barriers for the Pickens County recovery court, and then to go to the Garfield one, she would need the felony conviction.
Mm-hmm.
This has been one of my frustrations because I know that she's been raised in this country, and my feeling is that she speaks English well enough to participate in these things. I know it's more comfortable for her in Spanish, but I've tried to talk to her about being a little bit more flexible with that so that she can have some greater opportunities with some of these programs that you're suggesting, Your Honor.
Right. You were born in Aspen, and I know you moved away for a little bit, but you went to high school here, you were born here. Is there any willingness to do it in English?
Pues es que el problema es que no lo hablo bien. Sí lo entiendo, pero no lo puedo hablar bien.
Well, the problem is that I cannot speak it very well. I do understand everything. It's the problem that I have is when I speak.
Mm. I guess I'm just going to ask one last time. Do you have any interest in getting sober?
Sí.
Yes.
And are you willing to do what it takes to get sober?
Sí.
Yes.
Then why not do the inpatient treatment?
No sé, nada más.
I just don't know.
It's interesting, the family dynamic. I think grandma or mom, her mom is helping with the baby and things, but they've been detrimentally unhelpful in helping me help her and stuff. And so she hasn't had much support from her family other than with the child, which is frustrating because I would have liked to have a greater dialogue with them, but they have a history of playing games. And I don't attribute that to her, but it's made it extra frustrating in dealing with cases that I feel like she can have some better support, but they might be also frustrated with her too. I'm not sure. They won't talk to me.
And this is difficult because I certainly don't want Ms. Carol Vasquez to spend this time in jail. I want her to spend the time getting sober, not just for you, but for your child that you've now driven with drunk twice.
Twice.
I think you have one of the most serious problems with alcohol of anyone that's come before me, because you've let alcohol cloud your judgment to the point that you have put your daughter at risk of killing her. That you would be responsible for your own child's death. Not once, but twice you did that while you were on probation, For the first one, while you were joking around and not taking it seriously and not doing anything in class and getting asked to leave, not just not getting anything for yourself, but also making it less likely that other people in the class were getting something out of it, wasting their time, you made the decision again to drive drunk with your child, an infant that you were so drunk you didn't even put her in a child car seat. That is so incredibly dangerous. And why I think you've certainly done enough to deserve jail. That's not a question. I don't think that in the long run is going to help you or your family. The only thing that's going to help you is by getting treatment. But every single thing you've done in this case has indicated that you don't want treatment. You'd rather just stay in jail, which is a waste. It's a waste of the community. It's a waste of our resources. It's a waste of your time. It's a waste of the time that you have with your child. But you've done nothing to indicate that you want treatment. And I don't understand this idea that jail and inpatient treatment are the same. Jail, you're not getting treatment, maybe some, because there's AA and JBBS, but inpatient treatment is a way for you to change your life and be sober and have a relationship with your daughter that's healthy. And you're not willing to do it. And I share your attorney's frustration with that. And you don't even think you're an alcoholic. And I don't know what is going to wake you up. Because I would think for most people, getting arrested twice, 3 times for DUI, but twice for driving drunk with your infant in the car would be a wake-up call. And to you, it's not. And I don't want the wake-up call to be that you kill her. And that's the wake-up call. But I think that's the point that we're at. I mean, I think if you hadn't been in custody, you'd already be at a 4th DUI and you'd be eligible for recovery court because you'd have a felony on your record. That's how dire your situation is, and you just don't get it. So,
can someone please explain to me why this judge is struggling so hard? The answer to me is crystal clear.
If you're willing to do inpatient, I'm willing to grant you probation. If you're not willing to do inpatient, then I don't think there's a point in putting you on probation. I think we should just finish the sentence with jail, but I'll leave that up to you and what you want to do.
Do you have any feelings about what the judge should do, is what she's asking? And decide whether to do probation, and if you're willing to do treatment, or just close the case out with jail. And it's the problem with that is you still have to do a lot of those DUI classes in order to get your driver's license back eventually, regardless of what Judge Andrews does. So that would be my concern with not doing the classes and things, is because you'll have to do them eventually to get your license back.
Yeah, that's what I'm worried about.
Oh, go ahead.
It's a big decision. I'm happy for you to take the time to think about it.
Stop screaming at your computers, guys. She can't hear you.
Or I haven't asked the judge this, but since we were open to the idea of completing the sentencing at another time, if you need time to think about this decision because it's so important, then I could ask and see if that's an option. But at some point, we've got to make a decision for treatment or just doing jail and getting it over with. And nobody can force you to do treatment. I guess we kind of can, but courts don't usually like to do that because it's not very productive.
Pues yo pienso que mejor es, que mejor lo voy a terminar pues haciéndolo con los días de cárcel.
Well, I think that that's what's best is just to finish this with the days in jail.
Oh my gosh, there's an adult in the room. Look, guys, there's an adult in the room. It's the inmate. The inmate is the adult in the room.
Okay.
Segura?
All right. Then in 23T5007, I will go ahead and revoke your probation and resentence you to 365 days in jail. 22M193, I will revoke your probation, resentence you to 365 days in jail. Those sentences will be run concurrent to one another. How many days credit does she have at this point, Mr. Jovanovich?
I'd have to defer to the jailers. I think she's been in there for about 60 days at this point. But
Do we have a number on that?
56.
Okay. She's been marking them then.
Tengo una pregunta. ¿Cuántos días dijo? Es que no lo entendí.
A year in each
Sorry,
case.
how many days did you say? I did not quite hear that.
I said a year in each case, but they'll be run concurrent with 56 days of pre-sentence confinement credit. I'm disappointed, Ms. Kira Vasquez. That's not how I wanted this to go, but hopefully at some point you will get the treatment that you need. Thank you.
Just so she
Ya
knows.
no,
Go ahead.
ya no puedo cambiar la opinión de agarrar mejor lo del tratamiento.
Can I change my opinion about getting that treatment? Or is it too late?
At this point, it's too late. I've already made my order. You can certainly speak to, if you can work out a better plan with Judge Roth, you can file a motion to reconsider. And if that plan includes treatment, I would be open to resentencing. But at this point, the order stands.
In other words, you go in front of Judge Roth if you've changed your mind and want to do treatment, and she orders treatment, and there's indication that you're taking that seriously, then I could file something with this judge asking her to reconsider her sentencing. And certainly the prosecution has a right to have an opinion on that, and so does the judge because it's her sentence. But we can do that. As a side matter, I'm having problems with her family doing what they need to do to help me represent her.
Mhm.
And, our office debated very strongly, a little bit heatedly, about whether I should have withdrawn before today, even in this case. So to the extent that she can talk to her family, it's putting me in have a bad situation to keep coming down when there's no effort on her family to. I just don't do this solely because of money, but at some point I have bills and employees and
Right.
things like
Lawyers making
Right.
it
Well,
about him.
perhaps, I mean, if I did something like this to either one of my kids, my mom would not be supportive the second time. I mean, I don't think she'd be supportive the first time, but she would absolutely choose her grandchildren over me. And I think that's the difficult family dynamic because of the position that you've put everyone in by risking your child's life twice. So I get it, Mr. Jovanovich. I think that must be
It was a
difficult.
difficult dynamic even before this all
Okay,
happened.
okay.
I represented other people.
Okay.
But they're certainly not very, as I said, helping her. It has nothing to do with her decisions, but
Yeah.
there's a lot going on here behind the scenes. But I promise that myself and our office have really bent over backwards to try to help her and to accommodate a lot of these court dates.
Well, you entered in the one case pro bono.
Yeah.
Yeah.
So
I have a note of that. So, okay.
we're trying to help out, I promise. But if she could talk to her family and see what's going on there. I've already talked to her about this before, but if it was just me, it'd be different. But
Mhm.
other people
Right.
depend on me, so that's I can't for free all the time.
Ms. Vasquez, they do have AA at the jail and other services. Have you been attending any of those?
No, nomás estoy haciendo otras, bueno, voy a hacer otras clases que me dieron y pues sí, solamente eso.
No, I'm just going to start with some classes that they gave me, but that's it.
Okay, because if you're going to convince the other judge or me at some later point that you do want treatment, I would start by taking advantage of the opportunities that you have for treatment in the jail.
The last thing I'll say on the record is I've used to work with Judge Ross, so I know her pretty well. I think it would be in your best interest to reconsider the treatment thing. If you need to call me from the jail to talk to me or Mari about that, be glad to do that. But as a person that used to put a lot of people in jail, both as a judge and a prosecutor, I think my advice on how to handle this is significant and should be followed, but that would be my advice, is to reconsider that. As I said before, it gives you an opportunity to get treatment and has the judges feel a little bit more comfortable about working with you because you're not going to be as dangerous if you get treatment. My gut instinct is to try to help her out with this other stuff, despite this other drama that's going on, but I'm not pleased about it. But I'll probably be there for her with Judge Roth if I can be.
Okay, thank you. Then thank you, Ms. Vasquez. Good luck. All right, and then we have one, and Ms. Steinman, thank you for being here. Is this your client, Mr. Jovanovich?
No, it's rude.
That was so frustrating. That was so frustrating. And no matter how loud you yell and scream, this judge, I mean, normally I love the judges, and I'm not going to say I don't love this judge. I'm not going to say that at all. But it's like when you start dating someone and you see some red flags. You should stop and you should look at those red flags. This woman said every single thing she was supposed to say to go right to jail at the beginning. She did everything that you would expect for her to go right to jail at the beginning. And it's like, no, I can fix her. I can fix him. No red flags. I'll wear the red flags. Oh my gosh. I want to stick with Jersey judges because they send people to jail. In Jersey, in case you don't remember from my last streams, so in Jersey, if someone gets arrested, there's no like immediate, there's not a normal type of bond hearing like we have everywhere else, where, the defender always asks for an OR and then the prosecutor asks them to go right to jail. In Jersey, if the prosecutor says they want them to go to jail, that's it. Nobody can do anything. They go to jail until they go in front of a superior court judge to see if they deserve a bond. So in Jersey, they go to jail often. As soon as the prosecutor says, "Hi, Avalon," as soon as the prosecutor says, you go to jail, the judge can't even override it. The judge sends them to jail. Everywhere else, it's a PR bond no matter what. You killed 3 people. Here's a PR bond, but we're going to put a GPS on you. And you better not do it again. And if you do it again, you better not be drunk while you do it. And for the love of God, stay out of Fulton County. That's why I'm going to get more Jersey. I love Jersey. Oh, I also found a bunch more of Colorado. I mean, not Colorado. We had Colorado. California. And I'm trying really hard to get Alaska. I had Alaska like last year and I lost it. I can't find it. Guys, thank you so much for all the new people from all the other streams. Thanks for coming. I appreciate it. And to my normal crew, my Vibers, don't worry. I'm still going to post at my normal time. I promise. Just every once in a while, some people can't make it to 4 a.m. because they're sleeping like a normal person should be. So every once in a while, I'm going to post at a normal person hour. You know, like when people are still awake. But not tonight. Thanks, Fozzie. You're the best. Guys, Fozzie's the best. Jim, you're the best too. All right, and there's my lovely Lightfoot. Thank you so much for coming out, guys. I will see you next time. Behave, okay?